Welcome back. You're still tuned in to News and Views. My name is Salailo Makwidiri, and we're going to be kickstarting the show with something that's very, very interesting. Yesterday, there was a landmark constitutional court judgment, which has somewhat sent ripples through marriage law in South Africa, particularly for couples who entered into customary marriages and then later on went to civil marriages with antenuptial contracts. The Apex Court has made it clear that civil marriage does not erase an existing customary marriage, and importantly, that antenuptial contract signed after a customary marriage may be invalid without judicial oversight, keeping many estates locked in community property unless otherwise authorized by the court. We're going to be unpacking the legal, social, and maybe the practical side, and maybe fallout of this with Attorney Yousha Tayob, and we'll be exploring what this means for couples, what it means most importantly for women's property rights, estates planning, and how the law now treats customary marriage vis-a-vis civil marriages. And Yousha is joining us via our virtual platform. Salamu alaikum, Yousha. Thank you so much for joining us. Always a pleasure.
Walaikum salam wa rahmatullahi wa barakatuh. Jazakallah for the opportunity.
I think we'll jump right into it in the most simplest of terms for our listeners at home who are maybe trying to make sense of this ruling by the Constitutional Court. In the most simplest of terms, what does it mean? What does it mean? Can we maybe clarify if civil marriages do not dissolve or override customary marriages, the antenuptial contracts post-marriage, and how they all interact in this new ruling?
In essence, and I don't know what the real hoo-ha about all of it is simply this. Parties enter into a lobola traditional customary marriage in terms of the Customary Marriages Act, and what that requires is an agreement and a letter and an understanding of an intended and executed marriage. Mm-hmm. And what the Constitutional Court said yesterday is that if you enter into such a customary marriage, then any subsequent antenuptial contract between you post the lobola and or traditional and or customary marriage is invalid, which appears to be contractually sound. How the High Court could have ruled otherwise in the first place just doesn't make sense. It simply means that the customary marriage that you entered into without an antenuptial contract before, the validity of that marriage cannot subsequently be changed by virtue of the fact that you enter into an antenuptial contract excluding community of property later. So the default position practically for all marriages in South Africa is that it is in community of property. There are means to change that by applying to court or entering into a post-nuptial agreement, but certainly the antenuptial that you enter into post a customary marriage is invalid, and that's the net effect of yesterday's judgment.
And my next question would be, why does it matter? Why does this judgment matter for ordinary South Africans, particularly those who are married traditionally and then later on had a civil wedding?
Yes, so in essence, what the court is saying is that your customary marriage at the time that you entered into cannot simply be negated. I haven't seen the time periods that it effectively wishes for it to apply for. But in essence, what the court is saying is that a subsequent civil marriage altering the terms of the in-community of property customary marriage at the time of the customary marriage cannot simply be altered by virtue of an antenuptial contract entered into the parties a day, a month, or any time later than the customary marriage. And ultimately, that simply means that it remains an in-community of property marriage between the parties, and for the entire outer world to recognize that there's a joint estate as opposed to what the parties intend to do subsequently. So the customary marriage and the letters and the formalities followed in terms of the Customary Marriages Act cannot simply be negated by the parties post the lobola agreement.
There's been a conversation and commentary around how this ruling almost strengthens protections for spouses who may have been economically weaker, especially the women. Traditionally, women in the country would be the ones that are coming into marriage maybe with not as many assets. The men might be the breadwinners. Is this a win maybe for women and for vulnerable spouses?
An in community or property marriage certainly has its advantages and disadvantages. If both spouses are working, they build a joint estate. If we live in the traditional man's world, it's the man who goes out there and earns the keep, um, increases the value of his estate, and wife remains a housewife. But it all depends. I mean, it's a very subjective inquiry, but ultimately, it's a partnership, and it's an
Mm,
community or property partnership, and one earns and one spends, and both earn and both spend, and develop an estate. So, I think it's a very subjective inquiry. But I mean, you use the word traditional. So, the traditional home was mom's the sorry, wife's the homemaker, dad's the breadwinner, and that's where the estate develops. And certainly amongst the divorces that we do, the men earn substantially more and develop substantially more of an estate. So we even within the Muslim community, you have people who have gotten married at home affairs. The default position is in community or property. They then realize that this is against the deen, against the principles of the deen, and there's an out for it. There's an out, and the out
mm,
is a post-nuptial agreement. I mean, it's an expensive process because you've got to notify creditors and the like. But there is a means to rectify it called the most post-nuptial agreement. So I read the judgment. I didn't profess to know the circumstances of the parties in why it was referred, but it's really a big hoo-ha about something that for me is quite clear, that
mm,
the customary marriage agreement entered into prior to the anti-nuptial contract must be respected, and there is a means to change it. And I suppose the court just clarified that any anti-nuptial contracts executed after the Lobola Agreement are invalid. So those parties are back to an in-community or property estate. Whether there's benefit there for the parties in those marriages or not is a purely subjective inquiry. I mean, the extent of the now working woman class is substantially bigger than it was years ago.
Does this in any way affect Muslim marriages? We saw how over the years there's been an evolution of how the nikah and Muslim marriages in general have been recognized and are starting to be recognized by the government. Does this ruling in any way intersect, affect Muslim or any other religious kind of marriages?
So this particular ruling applies only to the interpretation and effect of the Customary Marriages Act. But if the same principles were to be challenged, I doubt that the Constitutional Court will apply different principles to the
Mm,
religious marriages. So it certainly would have the same effect, I would think. But this ruling only affects customary marriages for now. But I mean, ultimately, the position on Muslims married without anti-nuptials, default position is in community of property as well. So if anybody were to challenge an anti-nuptial contract post the nikah, I suspect this ruling will similarly apply. But we're just hoping that Muslims don't refer too many matters to the courts. Yeah.
Lastly, before I let you go, if you had to give our listeners, based on this ruling right now, maybe two or three things to remember, when they're getting into marriage, whether it's customary marriages or otherwise, how things have now essentially changed and what they need to keep in mind.
Yeah, so I think a number of organizations offer free services. Certainly, the MLA will accommodate people who need to attend to these queries. But in essence, the issue really is when you are making any form of big decision, and particularly nikah or a customary marriage or a lobola, it's very important to consult legal people, people in the know, so that you're advised how to act in terms of the Customary Marriages Act, in terms of the Matrimonial Property Act, the anti-nuptial contract. So, without wanting to punt for lawyers, you in essence just need to get a bit of guidance, and it's literally a 10 or 15-minute explanation for most people to have the anti-nuptial contracts in place in order to comply both with the Matrimonial Property Act and the Customary Marriages Act, in order to ensure that what you intend to do, because unfortunately these are discussions you need to have as young as you are getting married, is what proprietary system are we going to get married in terms of, is it going to be in community or property, is it going to be an anti-nuptial with or without an accrual, are there any special conditions that we need to stipulate in the contract. It's unfortunately emotion, but there's also a transaction being effected because it's a partnership. And unfortunately, we get to see the bottom end of it in the divorce, where the parties simply negated having any discussion on that issue, on those issues. And it can be an expensive, lengthy, acrimonious process thereafter.
We seem to be having some engagement. I think our listeners want to ask some questions, but we only have time for one question. Unfortunately, that I think our technical producer will be putting up on screen.
I'm happy. I'm happy for you to forward those questions in due course, and I'll answer them, and you can post them on your website, or we can have another session. Yeah, no issues there.
Yeah, all right. I think we'll just take this one for now. This comes from our YouTube channel at Here for Comments Only. They're asking, is it advisable for women to transfer existing assets to a trust fund before entering a polygamous customary marriage?
Look, your assets are your assets. What you want to do with them is your choice. Whether you transfer them to a company, give them to a sister, get a nominee agreement, it's your asset. Within the confines of the deen, Allah is the provider. Allah has provided that for you. What you do with it, you're also responsible for. So ultimately, it's your asset. Whether you agree, whether you decide to share it with in your polygamous marriage, is your choice. Whether you seek to protect it by other means is your choice. Um, Ultimately, I'm saying it's your asset, and you need to decide with what you want to do it. Do you want to share it with your polygamous spouse, or your spouse in a monogamous marriage? Do you want to share it with your children? Do you want to share it with your sibling? It's your asset. You're entitled to do what you do with it, subject only knowing that if you take it into a community or property asset, it's going to be shared uh, on death or divorce. So ultimately, my advice, whether it's a trust or not, whether I need to sit down with you and understand your financial situation to see whether trust is still a viable option. There's too many preponderables here, but ultimately the question is, it's your asset. You're entitled to do what you want with it. If you wish to share it with the polygamous spouse, then that's your entitlement. If you wish to share it with the monogamous spouse, it's your asset. You're free to do with it. But certainly the advice would be to protect your own assets. I mean, all of us acquire assets after a substantial amount of hard work and effort, and it's important to protect it, or at least have the discussion around it and say, these are my assets, and I want to formulate a way to exclude them from you being entitled to it, or I'm happy to share it with you. So it's a highly personal financial decision.
Well, there you have it, Attorney Yousha Tayob. Jazakallah so much for joining us. I know we're going to be getting requests to have you back on air, because I can see that our listeners have a lot of questions. We'll try to do that maybe sometime next week, but we're going to leave it here for now. Jazakallah so much.
Jazakallah. Assalamu alaikum wa rahmatullahi wa barakatuh.
There you go. That was Attorney Yousha Tayob giving us a very, very important and in-depth legal insight on that constitutional ruling, which essentially, well, it's a landmark one, but he seems to not understand, because this what's the wurara around it. But essentially, it is for couples who have entered into customary marriages. So customary marriages in the South African context would be lobola. It would be lobola. It would be mahadi. And then after that, you get into a civil marriage with an anti-nuptial contract. So the apex court, the biggest court in the land, essentially has made clear that civil marriages from now onwards do not erase an existing customary marriage. And importantly, that antenuptial contracts signed after a customary marriage may be invalid without judicial oversight. So yeah, I think that's very, very important to know. If you have any questions, I think you can hit us up. We'll try and get Yousha Tayob back on air sometime next week. But yeah, we're going to leave it here for now. You can engage with us. If this is affecting you in any way, if you have questions for Yousha, Tayob is always available for you here on Salam Media on request. We can have him back and we can try and dissect whatever legal issues that you're facing. And you can do that by calling us on studio line 801-168-00355, on WhatsApp 061-766-0355. Otherwise, going to say a quick break. When we come back, is hashtag Africa Focus feature.